Hello everyone, and thank you again for joining me. My name is attorney Deani Winter Funde, and I'm excited about the month of November as we talk about waivers. We finished up the month of October by wrapping up our humanitarian visas. It is only natural that we segue into waivers. What is a waiver? I spend a large amount of time in my practice counseling individuals that are inadmissible to the United States for one reason or another. Inadmissible maybe because they entered unlawfully, in other words, they snuck across the border, or inadmissible because they have overstayed their time in the U.S. For example, they were granted a 6-month length of stay, and it's now 3 years later and they're still in the U.S. Another area in which I counsel individuals on is criminal activity, meaning you have been residing in the United States without having lawful permanent status, and during that time, you have committed some criminal act. In an effort to keep families together or to promote family unity, and there are many policy reasons behind waivers, but under the Immigration and Nationality Act, there are options where individuals can get waiver. Keep in mind, though, this is one area of immigration law that I always highly recommend that you consult with an attorney. Why? Because it is super complicated. Remember, this is all based on statute, so it's statutory, whether you're eligible or not. So for the month of November, I am going to spend the time and I'm going to go through 3 big areas. I'll be looking at waivers, I'll be looking at exemptions, and then I'll be looking at permissions to apply, and I'll try to distinguish the 3 for you. There are many different categories for waivers, so I will not go into every single category. But keep in mind, if you think at any point during your immigration process you are inadmissible, or as we call it, you have some red flags, I encourage you to, after listening to this video, to consult with an attorney. Again, my name is Deani Winter Funde, and join me for the month of November as we talk about waivers of inadmissibility, as we talk about exemptions, or we can talk about permission to reapply. You can find me on Facebook, you can find me on Instagram, and until next time, my friends, walk good. Thank you again for joining me. My name is attorney Deani Winter Funde, and I'm an immigration law attorney in Tampa, Florida. This month, we're focusing on waivers. As I mentioned, I've spent a lot of time counseling clients and individuals that have entered the United States unlawfully, meaning they've either snuck across the border or they've entered and overstayed. For this month, we are focusing on waivers. One of the most popular kinds of waivers, or I should say the most common kind of waivers I come across, is that for unlawful presence, meaning the individual has no way to show how they entered the United States. For most, it means they might have come across the border in Texas or Arizona or California. You typically do not need a waiver unless somebody is about to apply for you. In other words, you're living in the United States unlawfully and you've been doing this for some time, 5-10 years, that happens, and you've now met a significant other. So your spouse is now ready to apply for you. The kind of waiver you will require will depend on how you entered the United States, and or if you've left while you've entered unlawfully, or the status of the person that is applying for you. For example, John Brown came across the border in Mexico. He is now married to a United States citizen. Because John Brown was not inspected by an immigration officer, he cannot adjust his status in the United States. So what I found that a lot of individuals make a mistake with is that John Brown simply departs the United States to go back to Mexico or to go back to Costa Rica to be processed. That is a kiss of death. John Brown will need a waiver in order to leave the United States to be processed in his home country. So for my next videos, I will be talking about what that waiver will look like for John Brown. But I want you to keep the John Brown hypo active in your head. The other kind of waiver I come across, and it's not so much a waiver, but is the exemption from the waiver. In some cases, and depends on the kind of visa that John Brown is applying for, or Jane Brown for that matter, he may or may not need a waiver as he might be exempt. So in the case of John Brown, when I'm sitting with him, I would kind of find out, okay, how did you enter? What is the kind of visa you're applying for? Is it asylum? And in that case, I could determine that he might be exempt. Join me in my next video as I talk about exemptions, and then the third category would be the consent to reapply. Again, my name is Attorney Diani Winter Funde, and I am an immigration law practitioner in the state of Florida. And until next time, my friends, walk good. We left off by talking about John Brown and whether he would need a waiver before he departs the United States. My friends, my name is Attorney Diani Winter Funde, and I am an immigration law practitioner in the state of Florida. This month, we are focusing on waivers. I left off with the hypo about John Brown. Now, John Brown has entered the United States unlawfully, and the question was, does he need a waiver? In screening clients, I always try to find out their immigration history. How did they enter the United States? Were they inspected at a port of entry? And I also try to find out who is petitioning for them. That will make a huge difference in whether they need a waiver or not. The other factor that comes into play is, are they exempt from this waiver? There are individuals that are filing for asylum or maybe filing for under the Violence Against Women Act. For those kinds of visas, they allow for certain kinds of exemptions. In other words, you may not need a waiver, or the waiver doesn't apply simply. So I always make sure that when I'm screening clients, I try to find out, because I would rather my client be exempt than to go through the process of a waiver. You will see from my later videos that this is a very intricate process because you have to prove all kinds of hardships. So one of the things I always try to do is to find out whether my client is exempt. So we've talked about waivers, we've talked about exemptions. The third category that we think of when we are looking at red flags are whether that person will need a permission to reapply. It is very important that you distinguish the consent to reapply from a waiver. The consent to reapply is not a waiver. In fact, I have had clients that need consent to reapply and a waiver. How is this different? Consent to reapply means that you have been deported or removed from the United States. So you have committed some kind of act, or you have entered unlawfully. However, you're now outside the United States. There's a few individuals that they were ordered removed but never departed, and so they will also need the consent to reapply. So those are the three big categories that I'll touch on for this set of videos during the month of November. Join me for my next week videos as I delve into waivers and what it looks like, what is the process, what do you need to show. Again, I ask that if you're joining me for the first time to like, follow, and share. And until next time, this is Attorney Diani Winter Funde, and walk good.
Hello